She called her bank on a Tuesday morning. Retired, 68 years old, 29 years as a licensed practical nurse in Columbus, Ohio. She had one question. Why did her checking account show a $35 charge she did not recognize? The woman on the other end of the phone told her it was a standard overdraft fee. She asked when she had agreed to overdraft protection. The representative said it was part of the account terms. She paid it. She had been paying it 14 times over 3 years without ever being told she had the right to say no. Without ever signing a single piece of paper saying yes. $490 gone, legally protected, completely recoverable, and the bank knew that. What happened to Dorothy Fenn is not an edge case. It is not a fluke. The Consumer Financial Protection Bureau, the federal agency created specifically to protect people like Dorothy, processed more than 1 million complaints last year alone. Overdraft fees tied to debit card transactions where no written consent was ever collected, ranked in the top 3 categories, every single year. The fees were not mistakes. The charges were not errors in the system. They were deliberate. They were collected from people who did not know that a specific federal rule, one that has been on the books since 2010, made the entire practice illegal without one thing, your signature. That rule is Federal Reserve Regulation E. And it is one of 7 fee types that cannot legally be charged to you, but are being charged to seniors every single day across this country. Nobody sent you a letter, nobody sat you down and explained it. The companies collecting these fees are counting on exactly that. If this channel is new to you, this is what we do here. Real rules, real dollar amounts, specific steps you can take this week. Hit subscribe and turn on the bell so you do not miss what comes next. And drop a comment right now. What state are you in? That one detail is going to change exactly how these rules apply to your situation. I read every single one. Fee number 1, overdraft fees charged without your written consent. Federal Reserve Regulation E went into effect on August 15, 2010. The rule is not complicated. Before any bank can charge you an overdraft fee on a debit card transaction or an ATM withdrawal, they are required by federal law to give you a written opt-in form. You must read it. You must sign it. You must say in writing, yes, I want overdraft protection, and yes, I understand I will be charged a fee if my account goes negative. If they never gave you that form, the fee is illegal. If you never signed, the fee is illegal. If the form was buried inside a 40-page account agreement and they did not separately present it to you for your signature, courts have sided with consumers on exactly this scenario. The average overdraft fee at a major U.S. bank is $35 per transaction. The CFPB reported in 2023 that American consumers paid $8 billion in overdraft fees in a single year. A disproportionate share of those fees came from accounts held by adults over 60, people on fixed incomes, people with Social Security deposits, people who are not watching their balance the way they might have when they were working. Dorothy Fenn's bank had no signed opt-in form on file, none. When she filed a written dispute, not a phone call, a written dispute, and cited Regulation E by name, the bank reversed $490 within 11 business days. She had no idea she could do that. She had been paying those fees for 3 years. Here's what you do. Call your bank and ask one question. Do you have a signed Regulation E opt-in form on file for my account? If they say yes, ask them to send you a copy. If they hesitate, if they cannot produce it, if they say it was included in the original account agreement, that is your opening. Every charge without that signed form is a recoverable fee. Write it down. We will get to exactly how to dispute it before this is over. Fee number 2. Junk fees on Medicare supplement enrollment. The Centers for Medicare and Medicaid Services, CMS, is the federal agency that oversees Medigap plans. Medigap is the private insurance that fills the gaps Medicare leaves behind. Copayments, coinsurance, deductibles. CMS has published explicit guidance referenced in the Code of Federal Regulations at Title 42 that prohibits insurers and brokers from charging administrative fees, enrollment processing fees, or application fees when a beneficiary is selecting or switching a Medicare supplement plan during a protected enrollment period. These fees go by different names: processing fee, enrollment assistance fee, plan review charge. They range from $45 to as high as $300. They are common, they are collected routinely, and for seniors enrolling during their Medigap open enrollment period, the 6-month window that begins the month you turn 65 and enroll in Medicare Part B, they are not legal. The rule is simple. During that protected window, an insurer cannot use medical underwriting to deny you, and neither the insurer nor the broker facilitating the enrollment can tack on fees that are not part of the approved premium structure. Outside of that window, the rules shift. But during it, which is exactly when most people first encounter these plans, exactly when they are most confused and most likely to simply pay what they are told, the fee cannot legally be collected. The state insurance commissioner in your state has enforcement authority over this. Complaints filed with your state's insurance department have resulted in full refunds. In documented cases, the CFPB also accepts complaints involving Medicare supplement products sold by private insurers. And what you are about to hear next involves a fee type that generated the single highest volume of senior complaints to the CFPB in 2 consecutive years. And it does not come from a bank or an insurance company. It comes from the place where some of you have lived. For decades, Walter Gruen spent 31 years on a factory floor in Dayton, Ohio. Retired machinist, hands that built things, a man who paid every bill on time, kept every lease, never once left a landlord in a bad position. When his memory started slipping in the winter of 2022, his daughter found him a memory care facility 40 minutes from her house. Good place, safe, clean. He moved in March of 2023. His landlord sent a bill 2 weeks later, $2,800, labeled early termination fee. Walter's daughter called the leasing office. She was told it was in the lease. She was told there was nothing they could do. She paid it because she did not know that Ohio is one of more than 30 states that have passed specific legislation prohibiting landlords from charging early termination fees to seniors who are vacating a rental unit to move into a licensed assisted living facility, memory care unit, or nursing home. The fee was not enforceable. It was not legal. It was collected anyway. Walter's daughter filed a complaint with the Ohio Attorney General's Consumer Protection Section 8 weeks after paying. She submitted the move-in documentation from the memory care facility, a copy of the lease, and a copy of the payment. Walter received a full refund of $2,800 4 months later. Fee number 3, early termination fees on leases when seniors move to care facilities. More than 30 states have enacted senior lease termination protection laws. The specific rules vary. Some require 30 days written notice. Some require 60. Some require documentation from a licensed physician confirming the medical necessity of the move. But the core protection is consistent. If you are a qualifying senior tenant who is relocating to a licensed care facility, your landlord cannot legally hold you to an early termination penalty. The states with the strongest protections include California, Florida, Texas, Virginia, Washington, Oregon, and Ohio, among others. In California, Civil Code Section 1946.7 gives tenants who are 60 or older the right to terminate a lease with 60 days notice if they are moving to a residential care facility with no early termination fee permitted. The fee does not disappear automatically. You have to invoke the protection. That means written notice, not a phone call, citing the specific statute in your state, along with documentation of the care facility placement. Landlords who refuse to comply after written notice can be reported to your state's Attorney General Consumer Protection Division. Small claims court is also an option for amounts under your state's threshold, which in most states runs between $5,000 and $10,000. If you paid this fee in the last 2 to 4 years, depending on your state's statute of limitations, you may still be able to recover it. Fee number 4, pharmacy dispensing fees charged on top of Medicare Part 500. Under Medicare Part 500, the federal prescription drug benefit, pharmacies are reimbursed through a plan negotiated rate that already includes a dispensing fee. That dispensing fee covers the pharmacist's time, the labeling, the transaction. It is built into the system. It is already accounted for. What some pharmacies do, particularly smaller independent pharmacies and certain mail-order operations, is add a separate dispensing fee on top of that rate and charge it directly to the patient at the point of sale. In some documented cases, these additional charges have appeared as a handling fee, a specialty processing fee, or simply an unlabeled line item on the receipt. CMS guidance published under the Medicare Prescription Drug Benefit Manual, Chapter 5, states clearly that pharmacies participating in Part 500 networks cannot impose additional charges on beneficiaries beyond the plan's cost-sharing structure, the copay, the coinsurance, or the deductible. Anything beyond that is a violation of the pharmacy's network participation agreement, and potentially a violation of federal billing rules. The dollar amounts per transaction are often small, $3, $7, $12. That is exactly why it works. Nobody disputes a $7 charge. But a senior filling 8 prescriptions a month at a pharmacy, adding a $6 handling charge to each one, is paying an extra $576 per year for a fee that federal rules say cannot be collected. If you see a line item on your pharmacy receipt that is not your copay and not your deductible, ask the pharmacist in writing to identify the charge and cite its authorization under your Part 500 plan. If they cannot file a complaint with CMS directly at 1-800-Medicare, You can also contact your state health insurance assistance program, known as SHIP, which provides free counseling and can review your pharmacy receipts at no cost to you. Fee number 5. Monthly maintenance fees charged when your account qualifies for a waiver. The average monthly maintenance fee at a major U.S. bank runs $11 to $17 per month. At the high end, that is $204 per year. Over 10 years, $2,040. Over 20 years, the length of a retirement for someone who stops working at 65, $4,080. For a fee that in many cases the bank was not legally entitled to collect. Here is how this works. Every major bank offers at least one pathway to a monthly fee waiver, a minimum daily balance, a qualifying direct deposit, enrollment in a specific account tier, or age-based eligibility. Many banks offer fee-free checking accounts, specifically for customers 62 and older. Some are required to offer them under the terms of consent orders they have signed with federal regulators. When a customer meets the waiver criteria and the bank charges the fee anyway, that is a billing error at minimum, and in documented cases involving banks operating under active consent orders with the CFPB, it has constituted a federal violation. The CFPB took action against a major national bank in 2022 for charging monthly fees to customers who had enrolled in accounts they were told were fee-free. The settlement totaled $160 million. The affected customers, many of them older adults on fixed incomes, received direct restitution. Check your statement right now. Look for any monthly or quarterly maintenance charge. Then call your bank and ask 2 things. What are the waiver criteria for this account, and do I currently meet them? If the answer to the second question is yes, and you have been paying the fee anyway, ask for a reversal in writing. 12 months of charges reversed on a $15 monthly fee is $180 back in your account. That is not nothing. 3 of the fees covered so far, the overdraft charge, the lease termination penalty, the maintenance fee, can be disputed and reversed through a written complaint alone. The next 2 are different. The federal government has stated explicitly that these fees cannot be charged to you under any circumstances. And they are happening in places most people would never think to look. June Halstead bought her home in a 55-plus community outside Tucson, Arizona in 2015. 62 years old at the time. Retired school librarian. She had read the HOA documents, all of them, before she signed. She knew the monthly dues. She knew the rules about parking and landscaping and guest policies. She thought she understood what she was agreeing to pay. In 2016, a bill arrived, $840, labeled Annual Reserve Replenishment Fee. It had never appeared in her purchase documents. It had never been put to a community vote. There was no board resolution authorizing it. It was created after she moved in, applied retroactively to the current year, and billed to every homeowner in the community as though it had always existed. June paid it. She paid it every year for 7 years. $5,880. She found out it was unenforceable 3 months ago when a neighbor's son, a real estate attorney, reviewed the community's governing documents at a homeowners meeting and pointed out that the fee had never been legally authorized under Arizona's Planned Communities Act. The board had no authority to create it. The charge had never been ratified. Every dollar collected was recoverable. June filed a demand letter the following week. The Teritsue's legal counsel responded within 30 days. She received a full settlement. Fee number 6. HOA fees charged without legal authorization. Homeowners associations have real authority. They can collect dues. They can levy special assessments. They can enforce community rules. But that authority is not unlimited, and it is not self-executing. Every fee and HOA charges must have a specific legal basis, either in the community's Declaration of Covenants, Conditions, and Restrictions, known as the CC&Rs, or in a properly noticed and recorded board resolution that follows the procedures laid out in the governing documents and in state law. Fees that do not meet that standard are not just unfair. They are legally unenforceable. Arizona's Planned Communities Act, Arizona Revised Statutes Title 33, Chapter 16, sets out exactly what HOA boards can and cannot do. Similar statutes exist in Florida under Chapter 720 of the Florida Statutes, in California under the Davis-Sterling Common Interest Development Act, and in more than 40 other states. The specific violations that appear most often in senior communities fall into 3 categories. First, fees created after purchase that were never disclosed in the original governing documents and were never ratified through a properly noticed member vote. Second, fee increases that exceed the cap established in the CC&Rs. Many governing documents limit annual assessment increases to 5% or 10% without a supermajority homeowner vote. Third, special assessments levied by board resolution alone. when the governing documents require a full membership vote for any assessment above a certain dollar threshold. For seniors in 55-plus communities governed by the Housing for Older Persons Act, known as HOPFA, there is an additional layer of federal protection. Fees structured to create discriminatory financial burdens on older residents relative to what would be charged in a non-age-restricted community can trigger Fair Housing Act review. If you live in an HOA-governed community, pull your CC&Rs and compare every fee you are currently paying against what is listed as an authorized charge. If a fee appears on your bill that does not appear in those documents, or if a fee was raised beyond the cap without a member vote, you have grounds for a written dispute. The Community Associations Institute provides a state-by-state legal resource directory. Your state's Attorney General Real Estate Division also accepts HOA complaints and in several states has enforcement authority to compel refunds. Fee number 7. Fees added by debt collectors that were never in the original agreement. The Fair Debt Collection Practices Act, known as the FDCPA, is a federal law passed in 1977 and enforced by the Federal Trade Commission and the Consumer Financial Protection Bureau. It applies to third-party debt collectors, companies that purchase old debts or are hired to collect on behalf of a creditor. The rule on fees is direct. A debt collector cannot collect any amount, including fees, interest, charges, or expenses, that was not expressly authorized by the original agreement that created the debt, or that is not permitted by law. That is the federal standard, not what the collector says is owed, not what appears on a collection notice, what was in the original contract. This matters enormously for seniors on fixed incomes. Third-party collectors routinely add collection fees, processing charges, and administrative costs to the balance they are attempting to collect. These additions often appear legitimate. They are stated on official-looking letterhead. They are presented as standard. They are frequently not authorized by the original agreement, which means collecting them violates federal law. The CFPB received 235,000 complaints about debt collection practices in 2023. Unauthorized fees and inflated balances were among the top 3 categories cited. The agency has taken enforcement action resulting in more than $500 million in consumer relief specifically related to illegal debt collection fees over the last decade. If you receive a collection notice, you have the right under the FDCPA to send a written debt validation request within 30 days of first contact. The collector must respond with verification of the original debt and the original agreement. Any fees that appear in the collection notice but do not appear in that original agreement are not legally collectible. You can dispute them in writing, report the collector to the CFPB at consumerfinance.gov, and in cases of willful violation, sue the collector in federal court for up to $1,000 in statutory damages plus attorney's fees with no requirement to prove actual financial harm. Seniors, stop paying these fees. They are illegal to charge, and most people don't even know it. Here is what to do this week. 3 critical steps. Step 1. Pull every bank statement from the last 12 months and mark every fee that is not a standard transaction charge. Write down the date, the amount, and the label used on the statement. You are building your dispute record. Step 2. Call your bank and ask specifically whether a signed Regulation E opt-in form exists for your account. Ask them to mail or email you a copy. If they cannot produce it, send a written dispute citing Regulation E and list every overdraft fee charged to your account in the past 24 months. Step 3. If you or a family member paid an early termination fee when moving to a care facility in the last 2 to 4 years, look up your state's senior lease termination statute. Your state attorney general's website has it. Write a formal demand letter to the landlord citing the statute and the amount paid. Step 4. Review your last 3 pharmacy receipts for any line item beyond your plan copay. If you see one, ask the pharmacy in writing to identify the charge and its authorization under your Part 500 plan. Then call 1-800-Medicare to report it. Step 5. Check your bank account for monthly maintenance fees. Call and ask whether you currently meet the waiver criteria. If yes, request a written reversal of the last 12 months of charges. Step 6. If you live in an HOA community, request a copy of your current CC&Rs from the association and compare every fee on your bill against the authorized charges listed. If anything does not match or if a fee was raised beyond the stated cap without a member vote, send a written dispute to the board, and file a complaint with your state attorney general's real estate division. Step 7. If a debt collector has contacted you, send a written debt validation request immediately. Certified mail, return receipt. Do not pay anything until you have the original agreement in hand. Compare every charge in the collector's notice against what the original contract authorizes. Any addition that is not in that contract is not legally collectible. Before you close this out, there is one more thing. Some of you are going to try to dispute these fees and hit a wall. The company will say the charge is valid. The representative will say there is nothing they can do. You are going to need to know exactly what to say when that happens, and who to call when the company refuses to move. Companies that collect illegal fees are not afraid of phone calls. They are trained for phone calls. They have scripts for phone calls. A representative who tells you the charge is valid and the case is closed has said that exact sentence to hundreds of people before you, and for them, it worked perfectly. The caller got frustrated, accepted the answer, and hung up. What stops them is paper. A written dispute with the correct federal citation, sent to the correct address, creates a legal record. It triggers a response obligation. It puts the company on notice that you know the rule by name. That changes the conversation entirely, because now the company knows that you know. And what they do next becomes part of a documented trail that a regulator or a judge can review. Here is exactly how to do it. Your dispute letter does not need to be long. It does not need legal language. It needs 4 things. First, your account information. Full name, account number, the address associated with the account, and a phone number where you can be reached. Second, a specific description of the charge you are disputing. The date it appeared, the exact dollar amount, and the label used on your statement or notice. If there are multiple charges, list every one with its date and amount. Third, the legal basis for your dispute. This is the part most people skip, and it is the part that matters most. Name the law. Regulation E for unauthorized overdraft. The Fair Debt Collection Practices Act, 15 U.S. Code, Chapter 41, Subchapter 5, for illegal collector fees. Your state's senior lease termination statute by name and code section. CMS guidance under the Medicare Prescription Drug Benefit Manual, Chapter 5, for unauthorized Part 500 pharmacy charges. Your HOA's CC&Rs, and your state's Planned Communities statute for unauthorized association fees. 1 sentence, 1 citation. That is enough. Fourth, your demand. State clearly what you are requesting. A full reversal of the charges listed, confirmation in writing within 14 business days, and a statement of whether a signed authorization document exists for the fee. Do not ask. State, send the letter by certified mail with return receipt requested. Keep the green card when it comes back. That card is proof of delivery, and it matters if this escalates. If the company does not respond within 14 business days, or if they respond by denying the dispute without addressing the legal citation, that non-response becomes part of your complaint. The Consumer Financial Protection Bureau complaint portal is at consumerfinance.gov. Filing takes approximately 15 minutes. You will need your dispute letter, any statements showing the charges, and the company's response if you have one. Here is what the data shows about what happens after you file. The CFPB reported that in 2023, 85% of complaints submitted through the portal received a response from the company within 15 days. The CFPB requires companies to respond. That is not a courtesy. It is a regulatory obligation. Of the complaints that received a company response, more than half resulted in relief, a refund, a reversal, a correction to the account. Not because the company suddenly developed a conscience, because the complaint is now in a federal database, assigned a case number, and associated with that company's regulatory record. Unresolved complaints at scale trigger examinations. Companies know this. Just 7% of eligible people. That is the share of people who qualify to file a complaint and actually do. 93% absorb the illegal fee, feel frustrated, and move on. The companies are counting on that number staying exactly where it is. File the complaint. It costs nothing. It takes 15 minutes, and it works. If the CFPB complaint does not produce a result, or if you want to escalate in parallel, you have 3 additional options. Your state attorney general's Consumer Protection Division. Every state has one. Every state accepts written complaints about illegal fee practices. In states with active senior protection units, Florida, California, New York, Texas, Pennsylvania, and Ohio among them. And as a result, these complaints are prioritized. The Attorney General has subpoena authority. The CFPB does not act on every individual complaint. State attorneys general do, especially when a pattern of the same illegal fee is being charged to multiple seniors in the same state. The relevant federal agency for your specific fee type. For Medicare and Part 500 violations, CMS at 1-800-MEDICARE, open 24 hours. For banking violations beyond what the CFPB handles, the Office of the Comptroller of the Currency for national banks, the Federal Reserve for state member banks. Each has its own complaint intake process. Each has enforcement authority. Small claims court. For amounts under your state's threshold, which runs between $5,000 and $10,000 in most states, you can file a small claims case without an attorney. Under the Fair Debt Collection Practices Act specifically, You do not need to prove actual financial harm to collect statutory damages. The law allows up to $1,000 per violation plus attorney's fees. That provision exists precisely because Congress understood that the individual amounts are small enough that people won't fight, unless the fight costs them nothing and the potential recovery is guaranteed. The AARP Foundation provides free legal resources for seniors navigating fee disputes and debt collection violations. Their legal hotline connects callers with attorneys in their state who specialize in exactly this area. The number is 1-877-987-2772. No cost, no obligation. They are there specifically for this. None of the 7 fees covered here are obscure. The laws prohibiting them have been on the books for years, some for decades. Federal agencies have taken enforcement actions involving these exact violations. Settlements have been paid, consent orders have been signed, and the fees are still being collected. The system does not advertise its own failures. The bank is not going to send you a letter explaining that the overdraft fee they charged last Tuesday required your written consent and you never gave it. The debt collector is not going to note on their invoice that the processing charge they added has no basis in the original agreement. The HOA board is not going to remind you that the reserve replenishment fee you have been paying for 7 years was never legally authorized. They collect because you pay. They continue because you do not dispute. And 85% of the time, 85% when someone does dispute, the company responds. When someone cites the law by name, puts it in writing, and sends it certified mail, the outcome changes. Dorothy Fenn got $490 back. Walter Gruen's daughter recovered $2,800. June Halstead settled for $5,880, fees paid over 7 years that a board had no authority to collect. None of them needed a lawyer. None of them needed a lawsuit. They needed to know the rule existed, know it by name, and put it in writing. Now you know. Take control of your finances today. If this changed something for you today, hit the like button. It takes 2 seconds, and it puts this information in front of more retirees who are paying fees they were never legally required to pay. Subscribe if you have not already, and send this to one person you know who owns a home, rents an apartment, or has a checking account, which is everyone. Drop a comment and tell me which of these 7 fees have you actually been charged. Have you ever tried to dispute a fee and been told no? I want to hear what happened. I read every single comment, and your story might be the one that shapes what I cover next. The next video covers something that affects every single person watching this who has money sitting in a bank account, a federal reporting rule that was quietly updated, that your bank is required to follow, and that almost nobody over 60 has been told about. You are going to want to see it.